The sale opened at noon. By 12:11 it was over, $200,000 raised from a few thousand fans in 11 minutes for a token the creator had launched that morning. No bank, no investor, no platform taking a third. The screenshots went everywhere. What the screenshots left out was the lawyer he had paid for 3 months before that day, and the single sentence he was careful never to say. Because the same 11-minute miracle has put other creators under federal investigation. The line between the two is thinner than it looks. Start with what a personal token actually is. A creator mints a batch of digital tokens tied to their name or community. Fans buy them. The creator gets capital up front, and the token can later be used to unlock access, reward holders, or trade between fans. It is, in theory, a way to fund your work directly from the people who believe in it, with no middleman. That is the pitch. It is genuinely powerful. It is also exactly where the law gets very interested, very fast. Here is the trap most launches walk straight into. The moment you sell something and tell buyers it will go up in value because of your effort, you may have sold a security, not a collectible, not a membership. A security, the same legal category as a stock, with the same registration rules. Most creators have no idea they crossed that line because they were thinking like marketers, not issuers. The fans were not buying access, they were buying the expectation of profit. That word, profit, is the Tripwire. The test has a name. In the United States, it is called the Howey Test, from a 1946 Supreme Court case. It asks a few plain questions. Is there an investment of money in a common enterprise with an expectation of profit derived from the efforts of others? If the answer to all of those is yes, it is a security no matter what you named it. A token, a coin, an NFT, a membership. The label is irrelevant. The economic reality is everything. Now watch how the creator who kept his money stayed on the safe side. He never promised the token would rise in value. He never told buyers to expect a return. Instead, he tied the token entirely to utility, what it unlocks. Holding it gave access to a private community, early drops, and a vote on what he made next. The pitch was, buy this to participate, not buy this to profit. He was selling a key, not an investment. That distinction is not wordplay. It is the difference between a product and a securities violation. Compare that to the launches that collapse. Regulators have repeatedly gone after token sales where the marketing screamed profit. Celebrities have been fined for promoting tokens without disclosing they were paid, and projects charged for selling tokens as unregistered securities while promising returns. The pattern is consistent. It was never the technology that drew the charge. It was the promise. Say the token will make buyers rich, and you have written the regulator's case for them. So the legal work happened before the launch, not after. Months ahead, the creator hired a securities attorney to structure the token around access and participation, scrub every word of the marketing for profit language, and decide who could even buy. He restricted the sale in ways that kept it inside legal lanes. The 11-minute raise looked spontaneous. It was the visible tip of a quiet, expensive, deliberate process. The creators who skip that process are not faster. They are uninsured. Understand what the downside actually is, because it is not a slap. Selling an unregistered security can mean the regulator forces you to refund every buyer, pay penalties on top, and in serious cases, face personal liability no company shields you from. Your $200,000 raise becomes a $200,000 refund, plus fines, plus legal bills. Several creators learned this after the money was already spent. The capital felt like a win. The liability arrived later, with interest. There is a quieter trap too, the secondary market. Even if your sale is clean, once a token trades freely, its price moves, and holders start treating it as an investment, whether you meant that or not. Hype spikes the price crashes, and angry buyers who lost money go looking for someone to blame. That someone is you, the creator whose name is on it. Launching a token does not end your responsibility at the sale. It begins a relationship with a price chart you do not control. So who should even consider this? Almost nobody, honestly, and that is the responsible answer. A personal token makes sense for a creator with a genuine community. a real use for the token beyond fundraising, and the budget to do it legally before launch. If your only reason is, I need money fast, a token is the most dangerous way to raise it. The token is a tool for participation, not a shortcut around securities law. If you ignore every other line, keep this one. The token is not the risk, the promise is. You can issue access, community, and participation with real care and stay on solid ground. The instant you tell people they will profit from your work, you have likely sold a security, and the law does not care that you are a creator. Write nothing you would not want, read back to you by a regulator, because if it goes well enough to matter, eventually it will be. He still has the community the token built. He still has the $200,000, and he still has it clean, because of a sentence he refused to say and a process nobody saw. The 11 minutes were real. They were also the smallest part of the story. The fans bought a way in, not a way up. That single restraint, holding the line between access and investment, is the entire difference between the creator who raised money and the creator who raised a federal case. The line is thin. It is not invisible. Walk it on purpose. If you want the gentler version of this idea, Episode 7, the newsletter that replaced Patreon with a token and tripled revenue, shows the same mechanics tied to pure access instead of fundraising. It is on this channel. Same key, far less legal exposure, and a model most creators can actually use.